Regina Campbell from the Campbell Law Group, and today we're going to bring you another how-to series. Today we're going to talk about 6 tips on how to protect your trade secrets. Now, often people say to me, Regina, what is a trade secret? And it's not any one specific thing. It can be a design, it can be a process, it can be a practice, it could be a pattern or a compilation of information that's important specifically to your company, such as maybe a client list or a combination of a client pricing and demographics that are not generally basically known. So this is where courts for the most part are going to look for to find whether or not a trademark exists. And we're going to talk about a couple of the other points in which the courts will go through to see if you as a company have also treated this product or this information, processes or improvements basically, as secretive and also protective as well in order to determine whether or not it's subject to protection. So these are 6 tips to try to ensure that you do get hopefully enforcement by the courts and you do the best you can to protect your trade secrets and anything that you've created. So step number 1, you want to register your trade secret, if it's a copyright or a trademark name or a patent, with any state, federal, and international entities that might be necessary where you're going to be doing business. Keep a close eye also on refining that registration over time as your processes and your patterns and so forth. The trademark may actually have upgrades, so to speak, right, or amended of information that makes it necessary to include to fully protect your trade name or your trade secret, basically. Number 2, basically NDAs and confidentiality agreements are strongly encouraged to be used in the employment setting, independent contractor setting, vendor, or even a partner setting. There's often some gaps in the law that do not provide for sort of protection. So for instance, some of these laws were written in the 80s and 90s in the United States, depending on state and federal as well. Some of the state legislatures have kind of caught up with technology, but some of the federal ones have not, and they're kind of behind on their definition as to what is protected and not included in the protection of certain acts. So to ensure internal use, for instance, or internal misuse by an employee and independent contractor, these agreements go a long way to make it very, very clear that there's under no circumstances is this employee or vendor or independent contractor allowed to use this information other than for their duties or their services they're there to provide to your company, and also what they can do after they leave your service. Okay, very, very important. Often they're found, these provisions are also put into employment agreements just to kind of round off a good, well-planned sort of employment package. Okay. Number 3, physical and cyber controls. So in other words, where is your information? Do you have information, your trade secrets and let's say your improvements, your patterns, or your process written in documents? If you do, it's very important to have these documents put away into a vault or into some kind of drawer with a key. Courts are basically going to look to make sure that you have reasonably protected your own information that you say is sensitive. If this information is sitting out, for instance, on a receptionist's desk where a pizza person can potentially grab or look at, it's more likely the court is going to find that it's not subject to be protected and that you yourself did not treat it with that type of level of scrutiny or concern. So why should the court do so? Cyber is just as important. So in other words, user management, user access. A lot of courts have looked to see how you've allowed your employees to have this information. And if you've tailored it specifically to the employee's needs, not to give them too much access to information that they do not require, it's not part of their job function. So in other words, if a receptionist has the client list and client pricing and all the strategies behind the company's plans, and they don't actually have a use for this information, the courts are likely to show that you yourself have not treated it with that secrecy and that protection that it needed, and it will not likely be upheld. So it's very important to tailor security plans and protocols and always look at them to ensure that you are showing protection and showing that you're showing that there's a need to it. So this is very sensitive to me. I've put it behind a vault. I put it behind a firewall. I have limited access to it, basically. Those are all the things that a court's going to look at. Number 4, work ownership. Sometimes people know it as work hire provisions or agreements. Whether it's with an employee, independent contractor, a vendor, or a partner, is very, very important for you to make it clear who owns the intellectual property. So if someone's taken a pattern that you've created, and that is your trade secret, and an employee or a vendor has improved the pattern, who owns the improvement? So It's very important that these agreements make that clear that it belongs to you. Because most people think that's a given, but it is really not. Sometimes there becomes a question as to ownership and who owns that sort of incremental additional piece. Number 5, I think another way also to protect your trade secrets and information in general is to segregate the information. So for instance, you have, say, 6 different levels to the process. Maybe have one employee handle each part of the process. So there's 6 different employees, and no one employee actually knows all of the information as to the entire process. Number 6, a response plan. Have one in place that includes also in your employee policies that the employees, independent contractors, and vendors and partners have to return all of the company's property back as soon as they leave or terminate services with the partnership. Make sure they have to create a certificate of destruction in order to ensure they don't have a copy on their phone or on their house computer for no reason they have this additional information once they've left your services or your partnership. Makes it very clear-cut line that this person cannot have this information and use it for any reason. Also, use what they call internet trolls. A lot of people don't like them, but you want to make sure your information is not being improperly used by another on the internet. Engage in software that helps locate this information. There's other firms that do this, as well as the proverbial internet troll that can also assist in this. And then, of course, have a plan. Have a cease and desist letter ready. Observe, document everything that might be out there that you believe is improper. Move on the cease and desist letter to ask this person to stop and to immediately return everything to you. And have a game plan and a time plan to enforce your rights so it doesn't look like you've been sitting on them. Well, hopefully this has been helpful, and I hope our other how-to series have been helpful. If you haven't seen them, please tune into our YouTube channel, become a subscriber. Also on our Apple Podcast channel, you can see our other Legal Zone podcasts that hopefully are helpful to you as well as our Campbell Corner that kind of talks about different people, different current events and stuff that might be of interest. And follow us on our social media accounts. Thank you, and I hope this was helpful. Thanks.